Thank you to all the members of the ALI for taking the time to watch this video and to hopefully review our draft. We're really sorry that we're not able to meet with you in San Francisco this year. And, it's important to stay safe, obviously. So we're going to do our best and make sure that you have the materials anyway. And as many of you know, a lot of the work is done offstage from the ALI annual meeting and the other meetings that we have. So we're going to just proceed as if, this is the right way to go. Okay, so what that means, though, is you can't wait until the annual meeting to stand up and make your comments. So what we need is for you to send them in to us through the ALI website. And even if that means you are not writing a memo or something drafted, written out by someone or something, even if you just write comments on the document itself, scan it and send it in, so long as it's legible, we will certainly take all of that stuff and that material into consideration. So what we're going to do now is do a very brief summary, survey of the materials we have. So the first section I wanted to highlight is one that we've had before the council, we've had before the membership, and obviously the advisors and the MCG several times. And this is section 10, which is in chapter 1, on money damages claims against the United States. We've worked hard over the course of the time of this restatement. The ALI has undergone lots of discussion about what to do about with sections of parts of restatements that are embedded, basically parts that come from where the black letter comes from codified law. And so in this case, we have two statutes that we've put together into our a black letter, the Tucker Act and the Indian Tucker Act, which are statutes that open up the federal courthouse doors to claims against the United States for money damages. In this context, those particular kind of claims have very special prerequisites that require tribes to show certain jurisdictional facts before they can bring a claim against the United States. The next section is that's part of this is section 33, which is another sort of section that's been hanging around for a long time that we're trying to clean up for the last draft. And I'll turn that over to Kaighn Smith, one of our co-reporters.
Thanks, Matthew. So section 33 has had a fair amount of work done on it. It addresses the lawsuits against tribal officials and individuals in the aftermath of the Supreme Court's decision in Lewis v. Clark, which held that a driver of essentially a tourist vehicle having to do with the Mohegan Sun of the Mohegan tribe in Connecticut could be sued in its individual capacity for torts arising off of the Mohegan Reservation, actually in the state of Connecticut. I'll just give a shout out to Judges Fletcher and Canby of the Ninth Circuit, who really helped fashion Section 33, and Professor Struve as well. It's not an easy area. There's a lot of sort of counterintuitive aspects to it, but at the end of the day, I think we've spelled out that law in a very succinct fashion to lay out the real party and interest rule. So it's there for your overview, and we welcome any comments.
Thank you very much, Kaighn. So the next big bulk of the restatement that is available for your review is from chapter 3. Subchapter 1 is about state authority in and around Indian country. And we've carved up this area of law as best we could. It's territorial, and it has to do with sovereignty. So states can regulate, states can tax. Indians, non-members, in Indian country, and to some extent, but not to the full extent. And so the first four sections of subchapter 1 deal with sort of the compartmentalized analysis that the courts have adopted in relation to various kinds of state authority to tax and regulate Indians, non-Indians, and others within Indian country. We also have some specific sections relating to Public Law 280 and similar type statutes that extended, where Congress extended civil jurisdiction to states in Indian country. And we have a section later on how much of after the litigation is over, what happens typically is that the state, the tribe, and sometimes the federal government will reach some sort of agreement together that is, for all intents and purposes, is a treaty, just not a treaty under the Constitution. So we have some material on that as well at the end. Kaigh's going to take you through the provisions from Chapter 4 that we have.
Okay, so Chapter 4 is the chapter on economic development in Indian country, and it's broken down to 2 subchapters. Subchapter 1 is tribes as economic regulators, and subchapter 2 is tribes as economic actors. Chapter 4 was largely completed up until last year, but we held out the specific sections that are before you now in order to make sure that they were fully consistent with the parts of the restatement addressing the powers of states in Indian country and tribal powers in general, which are chapters 2 and 3. So having completed those 2 chapters for the most part, we were now prepared to go back and finish out those related parts or sections of Chapter 4. So Section 52 addresses tribes' regulatory authority over activities on Indian lands. That very much tracks what we'd already laid out in Chapter 2, but it makes it more specific with respect to economic development. For example, it enumerates tribal powers to regulate the environment, to regulate employment relations, to have corporation codes, UCC-like codes, and the like. So that's Section 52. Section 53 addresses tribes' adjudicatory powers within Indian country and enumerates those powers, which are essentially the power to enforce the regulatory laws that they can enact and implement under Section 52, and also causes of action arising in common law. So that's Sections 52 and Section 53. Section 54 addresses tribal authorities over non-tribal citizens in Indian country. For those who practice in this field, those principles are well established. We lay those out. There's some variation in the way those principles work, whether the activity is on reservation or trust lands, stated broadly, as opposed to so-called fee lands owned by non-tribal citizens within the exterior boundaries of reservations. Those are known as checkerboard reservations, which are the product of the allotment era when there was an assimilationist policy to try to sell off a lot of tribal lands to non-tribal citizens. In that context, there's a special rule that limits tribal jurisdiction over non-citizen fee lands unless there is essentially a contractual relationship between the non-citizen and tribal members of the tribe, or lease arrangements or the like, or the activities at issue would have a direct effect on the political integrity or health and safety of the community. We lay out those general rules in Section 53. So then we have, I'm sorry, that was Section 54. Then we have Section 55, which is on state adjudicatory power and regulatory power within Indian country, and that essentially tracks the lessons we've already drawn out in Chapter 3. So it's a succinct restatement of what's already laid out in those earlier chapters, but of course with some emphasis on economic development. Section 63 is a very interesting section because it generated very interesting debate within our advisory group, and it has to do with tribal consent to state court jurisdiction, and in only recent years, the law has come into clarity with respect to the ability of tribes to consent to state court jurisdiction. And we draw upon that, the recent developments in the law to lay out the reality that indeed tribes can, through contractual relations and otherwise, consent to be sued in a state court. It's an actual exercise of tribal sovereignty to choose to be subject to suit in a state forum. It's not an intrusion upon tribal sovereignty, which was the past barrier that raised some questions about whether that might be a viable path to state court jurisdiction over contractual disputes that arise in Indian country. So we're actually very pleased about the way that Section 63 has come out, because it helps to clarify an area of the law that in the past has been rather murky. Then turning to Section 67, we lay out the principles of tribal court exhaustion, which is a doctrine arising out of a couple of Supreme Court cases, establishing that out of principles of comity, before a state or a federal court that has concurrent jurisdiction over a cause of action arising in Indian country, the court should stay its hand to allow the matter to be resolved through the tribal forums in the first instance, or dismiss without prejudice to allow that exhaustion to take place. It's a doctrine grounded in respect for tribal sovereignty and the necessity for tribes to be governing matters at their local level before foreign forums address a matter over which they have concurrent jurisdiction. And then our last section is an important one to just flag that a number of contracts that tribes enter into or their enterprises enter into need to be approved by the federal government. This is a layover from sort of paternalistic times, but still very real. Under Title 25 of the United States Code and through various regulations, certain contracts have to have federal approval. Probably the most obvious one these days that comes up is management contracts with respect to gaming in Indian country, to make sure that they are fair, that they don't involve any nefarious individuals or matters, to ensure their integrity, so that tribal gaming is undertaken in compliance with the intentions of Congress and for the best interests of tribes. But there's a host of contracts that still require federal approval. It's interesting, I was just discussing this the other day with a colleague, that when I first started practicing law, every attorney contract with a tribe had to be approved by the Secretary of the Interior. Under federal law, you couldn't represent a tribe without it being signed off by the federal government. So that's sort of a holdover and a very important number of statutes in that regard, because if compliance is not made, those contracts can be considered void and without effect. So that's the end of Chapter 4.
So we also did a subchapter on the Indian Gaming Regulatory Act. This is a very heavily statutory section. So we've taken the most recent learning we can from the ALI as to how to deal with black letter that is guided by federal statute. We did not cover all of the Indian Gaming Regulatory Act. Much of it is not all that controversial, but there are multiple sections that several of our advisors were very keenly interested in us covering. So in particular, what lands can be used for gaming is obviously a very critical question. There are specific Indian Gaming Regulatory Act preemption type cases and issues relating to whether and to what extent state law applies to gaming activities, particularly business vendors, gaming vendors of Indian tribes who are non-members. We also have sections on the types of Indian gaming that are available. Kaighn mentioned in Chapter 4, an earlier section, that gaming management contracts are also absolutely critical. A lot of tribes don't run their own casinos. They enter into management agreements with gaming vendors, gaming managers, and those are heavily regulated and sometimes litigated contracts. There are also issues relating to gaming on off-reservation or after-acquired lands, and additional sovereign immunity issues that we cover in the restatement. The last chapter of the restatement, we're going to jump ahead to chapter 6, which is the natural resources chapter. Here you're going to see more descriptions of the kinds of tribal property interests or Indian property interests there are on reservations. This first section in chapter 6 is section 120 is about Aboriginal title. Is the codification effectively the restatement of the law that the Supreme Court laid down as far back as 1823 in Johnson versus McIntosh. But most of the rest of subchapter 1 on Indian lands and property are about the ownership of the various types of property interests on reservation lands. Subchapter 2 is basically treaty rights, although it's a little bit broader than that because a lot of tribes have rights to hunt and fish on and off reservation that may not derive from treaties. But we cover all the rights of Indian tribes and their citizens to engage in hunting, fishing, gathering, agriculture, all sorts of things related to their homelands, the reservations, and also the ceded territories of lands that the tribes have sold during the treaty process. And the very final subchapter we have for the restatement is Indian water rights. This is sort of an offshoot of the treaty rights subchapter we just had on hunting and fishing and other kinds of treaty rights and Indian rights. But these are very specific types of rights related to Federal Reserve water rights, Indian rights to waters in the West in particular are obviously hotly contested. And here we try to restate the law of the West effectively in terms of federal and Indian reserve water rights. And that pretty much covers everything we have. We want to thank you for watching our video, taking a look at our draft, and strongly encourage you to send in comments, suggestions. We try, but we are not perfect, and please help us to create the more perfect project that we can. And thank you very much.
Thank you very much.